Hey y'all, I am the Loud Little Ducky. Today we're going to be going over Karen Read's motion to dismiss hearing, and we're going to talk about jury interference, discovery of timeline, the Sally Port videos. Are the videos exculpatory? Does prejudice exist? Some destroyed cameras, lack of metadata, and most of all, should this case be dismissed with or without prejudice? Let's jump into it. So first, we're going to go over some law and like what is the prosecution team? Because one of the most used lines in the motion to dismiss hearing is Hank Brennan saying the prosecution didn't know. So, and this is off of Massachusetts Law Government site. I will link it in the description box. So we're getting it straight out of Massachusetts and how things work there. So the prosecution team, for the purpose of this rule, the prosecution team includes all persons under the prosecuting office, direction, and control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecuting office or have done so in the case. The prosecution team includes, but is not limited to, A, personnel of police departments or other law enforcement agencies who were or are involved in the investigation of the case before or after charges were issued or were or are involved in the prosecution of the case. Proctor, that includes you. B, personnel of other governmental agencies who, in conjunction or collaboration with the prosecutor, were or are involved in the investigation or prosecution of the case. C, forensic analysis, crime laboratory personnel, and criminalists employed or retained by the state or local government who were or are involved in the investigation or prosecution of the case. D, victim witness advocates and investigators employed by the prosecuting office. And E, members of joint state and federal law enforcement task forces who were or are involved in the investigation or prosecution of the state. So A through E is also a part of the prosecution. Lally, McLaughlin, and Brennan. Stop saying the prosecutors didn't know, because they are one and the same in the law enforcement and this. You know this, Brennan. Stop arguing it. Now let's go over exculpatory evidence. A1A3. This provision requires the prosecution to provide automatic discovery of any facts of an exculpatory nature. It derives from the constitutional requirement established in Brady v. Maryland from 1963 that the suppression by the prosecution of evidence favorable to an accused upon request violates due process, where the evidence is either material to guilt or punishment, irrespective of good faith or bad faith of the prosecution. And then it cites cases. This duty is also an ethical one imposed on the prosecution by the Supreme Justice Court Rule 307, RPC 3.8D. You are not allowed to suppress evidence. Proctor. And if Proctor knows, prosecution attorneys know, because Proctor is a part of the prosecution team. If you go to this website where I got these from and you pull up these sections, the blue links, actually, if you click on them, they will take you to those cases so you can see more about them if you are interested in that. Like I said, that will be linked in the description box. The term exculpatory is not intended to be technically construed as encompassing alibi or other complete proof of innocence. Rather, case law at present present defines exculpatory evidence to include, but not necessarily be limited to, all information that is material and favorable to the accused because it tends to cast doubt on defendant's guilt as to any essential element of the crime charged, including the degree of the crime, or tends to cast doubt on the credibility of Commonwealth witnesses, or on the accuracy of scientific evidence that the government anticipates offering in its case in chief. So if evidence is going to possibly cast doubt on a witness called by the Commonwealth, Proctor, Buchanan, any of them, then it has to be turned over and is considered exculpatory. The SJC interpreted the Brady obligation as encompassing evidence which provides some significant aid to the defendant's case, whether it furnishes corroboration of the defendant's version of facts, calls into question a material, although not indispensable, element of the prosecution's version of events, or challenges the credibility of a key Commonwealth witness. And then it cites some cases. It talks about impeachment material, defining exculpatory evidence, and the legal consequence of non-disclosure. The SJC has advised that even minor prior inconsistent statements are exculpatory in a case of an important witness, and urged prosecuting attorneys to become accustomed to disclosing all material which is even possibly exculpatory as a prophylactic against reversible error and in order to save court time arguing about it. And then they cite a case. All right, so let's see. Even minor prior inconsistent statements are exculpatory. Cast doubt of credibility of Commonwealth witnesses. So when Judge Cannoni asks, how is it exculpatory? Well, if it can be used to cast doubt on Trooper Proctor or Buchanan, or, DGM Petro or Tully or any of those people, if it can cast doubt or even go towards proving a minor prior inconsistent statement, it is considered exculpatory. So just right there, it is exculpatory when you hide stuff that can prove previous statements wrong and can cast doubt on the credibility of somebody. Exculpatory. Say it with me, everybody. To establish a violation of the rule of Brady v. Maryland, supra as incorporated herein, the defendant must demonstrate upon review that evidence actually existed. That evidence would have tended to exculpate him. Then it cites some cases, and that Commonwealth failed to disclose it on proper request, even though Brennan will say there wasn't properly requested. But as of the trial, when Lally sent in a request for surveillance video, they were on notice then to hand it over, and they didn't. I don't know when the first time Sallyport surveillance video was mentioned in this case. If it was in an oral argument, Brennan says there's never a motion that mentioned it specifically. Even though there was, video and stuff, crime scene, you would think that things that are in regard to chain of custody of the murder weapon and the storage of the murder weapon would be included in that. Brennan disagrees with that. Evidence in possession of the police is Brady material even if the prosecutor is unaware of it. So the prosecutor has a constitutional duty of inquiry. Evidence in the possession of the police is Brady material, even if the prosecutor is unaware of it. However, there is no duty to search for exculpatory evidence outside the Commonwealth's possession. Well, we know that the Sallyport videos were not outside of their possession because law enforcement had them. It was well within their possession. Police do not have a constitutional duty to perform any particular tests. Nobody asked them to. Evidence in government hands, but not within the possession, custody, or control of the prosecution team presents a special problem. The Supreme Judicial Court found that a particular evidence in the files of an internal affairs division of the police could be exculpatory evidence to which the defendant was constitutionally entitled, but because the International Affairs Division was not a part of the prosecution team, it could not be reached by the discovery mechanism of Rule 14. The proper mechanisms in such cases is a subpoena, so they would have needed to subpoena it and then it be handed over and all that. That is not really what we are talking about in this case. Although exculpatory evidence is included within automatic discovery, if the defense is aware of the items that may be exculpatory that have not been delivered by the pretrial conference, it should file a discovery motion specifying the evidence under subdivision, as the magnitude of error and non-disclosure is a part of function of the specificity of the motion. Brennan likes to say there was not enough specificity, whatever the word is, you know. In addition to preserving the issue for appeal, specificity can operate to avoid appeals by directing the attention of the prosecutor to those particular materials which the defendant believes would be helpful. A prosecutor cannot be expected to appreciate the significance of every item of evidence in his possession to any possible defense which the defendant may assert. And this is kind of stuff that's Brennan's arguing is like, how do we know what they're going to use and what they think is important if they don't give the specificity of it? Specificity. That word is going to trip me up today. And I get it. Yeah, you may not be able to, but if you have it, you turn it over. Automatic discovery. Also, if the word "give me the Sallyport surveillance videos" have been mentioned in oral arguments or anything like that, Lally knew that these needed to be handed over. Massachusetts State Police knew that they needed to be handed over in the first trial, before the first trial. So, yeah, Brennan, you might not have been here, but it was mentioned, and they were well aware. So to try to play dumb now is just not going to work. I mean, it may with Judge Bev Cannoni, but it ain't working on anybody else. Assembly and disclosure of those materials, and thus the entire pretrial phase of the proceeding, is expedited by specific motions in such cases. Subdivision A1A, mandatory discovery. This provision lists the items that the prosecution must produce for discovery, with the qualification that the prosecutor's automatic discovery obligations is confined to asserting and delivering relevant material it or its agents already possesses or control. If you possess it or you have it in your control, you turn it over. The first paragraph of this subsection limits the Commonwealth discovery obligation to material in possession, custody, or control of the prosecutor, persons, under its direction and control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or who have done so in the case. Police are under your control, and if the police have something in their possession or custody and control that involves the investigation, it is mandatory for it to be turned over, says Massachusetts law. This language, inserted in 2004, is not intended to change existing case law, but to reflect it. The language is specifically drawn from Commonwealth v. Day from 1992, also stating that a prosecutor cannot be said to suppress that which is not in his possession or subject to his control. And we're not asking for anything that is not under the prosecution or people that are considered the prosecution team to hand over things that they don't have in their custody or control. But the Sallyport videos, they had. Day and many cases since describe the prosecution's duty of disclosure as extending to all discoverable material existing in its own files. Existing and own files. It was in Proctor's files. And in the files, who have participated in the prosecution. The latter officials are usually police, so they're saying the police usually have this stuff, may include others assisting in the prosecution, but we know for sure police because they mention it. The SJC reversed a conviction because the prosecutor failed to turn over evidence he did not know existed, but which was known to the Commonwealth's crime lab because the prosecution had a duty to inquire. Yes. Yes. Turning over convictions. If she is convicted, they will probably reverse it due to the prosecution failing to turn over the evidence in which somebody knew existed. Talk about concerning of the existing such tests. Victim witness advocates are a part of the prosecution team and are subject to the same discovery rules. It is also clear, however, the scope of the prosecutor's duty of disclosure does not extend to the complainants and independent witnesses who are not agents of the prosecution with regard to some aspect of the case. Well, what's interesting in this case is that many of the witnesses are actually a part of the prosecution team as well. So, you know, the Kolokephises don't have the same things as like Proctor and Buchnick and Tully and the Alberts and all that, Higgins, things like that, but, you know, we know the ones who do. And then it talks about medical records, Commonwealth v. Weines, 1998. Rule 14 does not reach Internal Affairs Division records because IAD is not a part of the prosecution team. Under A1A, each of the following items must be produced for the defense at or before pretrial conference, provided it exists and is relevant to the case, within possession or control of the prosecution or its agents, and not the subject of a motion for protective order, which stays its production under subdivision A1C. Even before 2004 revision, the prosecution team was required to turn these items in district court and Boston Municipal Court pursuant to some rules which eliminated trial de novo and mandated broad discovery to the defense. Rights and duties are ephemeral indeed without remedies. ABA standards, supra comments at 107, subdivision C1 is intended to provide the general rule and is based on that assumption that the trial court is in the best situation to consider the opposing arguments concerning a failure to comply with the discovery order and to fashion an appropriate remedy. Remedies for non-compliance with discovery requirements could include a further order of discovery, a continuance, exclusion of certain testimony, which we know the defense does not want things excluded. I don't think she's going to issue a continuance. She might, because so much still needs to be done, and we're starting in a few weeks with voir dire for the jury, or such other order as the court deems just under the circumstances. C1. A continuance, or in some cases a mistrial, may be proper remedy when delayed disclosure leaves the defendant unable to make effective use of the evidence in presenting his case. There is, it should be noted, a statutory limit on court's power to grant a continuance without the defendant's consent. When the defendant is in custody, provides a 30-day limit for such instances. That is not a thing because she's out of custody, like not sitting physically in the jail. I mean, she's still in the custody of the Commonwealth, but she's not sitting in jail during all this. A dismissal barring retrial may be required when discovery violations has resulted in irremediable harm to obtain a fair trial for the defendant. And this is where we heard Alan Jackson talking about this is irremediable harm. Like the fact that they hid it. But what I think Judge Bev is going to say is, well, no, you didn't have it in the first trial, and she hasn't been convicted yet, and so I would just mistrial and give you a new trial, and so now we're having a new trial. So there, it's fixed. But the thing is that I still do not think that they have the entire video footage from when Karen Read's car was in that Sallyport. And so it needs to be the entire time that it pulled in and left from each of those camera views that we have. We need to see all those 6-hour blocks, not little snippets here and there. And if things have been altered, then that's not original footage. Things have been messed with. You're not going to be able to fix that stuff. And the fact that we're missing metadata to even prove or disprove those things is a problem. And I don't think a mistrial, new trial fixes that. All right. Thank you for sticking with me through this. We are fixing to be getting into the timeline, and I will also try to timestamp things so that you can go to the parts of the video that you want to go to if you do not want to listen to the whole thing, but I do hope you do. So section 14.2J, sanctions for non-compliance. This section makes one change to a prior rule. This section sets forth the judge's authority to impose sanctions for non-compliance with discovery obligations and adds to the prior rule examples of possible sanctions. Rule 14.2J1, sanctions for non-compliance with discovery obligation or discovery orders must be remedial in nature and tailored appropriately to cure any prejudice resulting from a party's non-compliance and to ensure a fair trial. Citing some cases, this broad range of orders a judge may impose in response to a failure to comply with discovery orders may include further orders for discovery, continuances, exclusion of evidence, adverse jury instructions. She could do this one. Don't know that she will. A dismissal with or without prejudice, or other appropriate steps. So the thing is if she dismisses it with prejudice, that means the Commonwealth cannot file these charges against Karen Read ever again. It's dead in the water. And you have nobody to blame but yourselves. Do better work. Do not hide evidence. Do not tamper with evidence. Stop the bullshit, basically. Or she can dismiss it without prejudice, which means they can just file it again. And that one doesn't make sense to me because we're fixing to have a new trial. So all it would do is end this one. And then they would start basically going towards a third, even though we didn't have a second. And all of that. So that one just doesn't make sense. Do I think she's going to do that? Probably not. And hopefully she's not convicted and we don't have to find out what an appeals court would say. But if she does get convicted, this is going to possibly be a huge appellate point. Commonwealth v. Washington from 2012, holding trial judges' dismissal with prejudice of indictments was not an abuse of discretion, where a judge properly found Commonwealth deliberately, willfully, and repeatedly failed to comply with discovery order. Well, we know that they have deliberately done it. Proctor has, at least. He willfully did it. And them repeatedly failing to comply with these orders for the last 3 years is proved when this incident happened like 3 years ago, and in 2025, we're still getting new evidence. Oh, we're done. We've given you everything. So it says contrast Frith, but it says Commonwealth's failure to conduct a reasonable inquiry concerning existence of other material subject to discovery, although mistaken, was not done in bad faith, and imposition of punitive fine on the prosecutor was an abuse of discretion. So in that one, it was this was existent of other material that was not in their possession or control. And the judge was like, I don't care, I'm giving you a fine. They said, no, that's not good. But in the other one where they have it in their possession and control, the mandatory discovery happens. And if you deliberately, willfully, and repeatedly fail to comply with these discovery orders, there's Judge Cannoni's way of being able to dismiss this with prejudice. Do I think she's going to take this out and use Commonwealth v. Washington? No. But it's there for her to use, and she is allowed to do it. Because I don't think anybody would be questioning whether this was done deliberately, willfully, or repeatedly, or that this stuff was not in their possession and in the control of the prosecution team as a whole, which includes law enforcement. All right, let's move to the timeline. So we have on January 29th, 2022, Boston officer John O'Keefe was found at 34 Fairview at 6 a.m. I don't know if he was dead on arrival. With the body temperature being in the 80s something, I don't know if that would be considered a body temperature of somebody that has been dead. But we do know that it was like 7:30ish when he was actually pronounced deceased. So he could have still been alive, but this is when he was found at 34 Fairview. Then at 5:30 p.m., the tow truck, followed by Sergeant Buchanan and Trooper Proctor in the police cruiser, arrived to Canton PD Sallyport with Read's basically Lexus on it. And something I am wondering about this is there dash cam footage from this police cruiser from when they were following the tow truck back to Canton PD Sallyport? Or is there video of the dash cam of the little police officer that was sitting like in the driveway as the tow truck and Proctor and Buchanan and the police cruiser following behind? If there's dash cam there, that would show Karen Reed's taillight on her Lexus. I don't know how the dash cam stuff gets turned on, if you can turn it on and off, or if it's always on. But that is something we have not seen, is dash cam footage from that. Then we have from 4:54 to 5:45 p.m. or 5:45 p.m. the CERT team. So 4:54, 4:56, and 5:41 p.m. the CERT team arrived. The search began after all of the CERT team members were there, and at 5:45 the first piece of taillight was found. So the Reed's Lexus SUV has been in the Sallyport for about 15 minutes before the first taillight piece is found. Some might wonder if that 15 minutes was enough time. And remember, the CERT team only found 3 pieces. The rest of the pieces were not found till later. So all they needed to do was get 3 pieces of taillight there. And then on February 1st, 2022, that is when the photos of the Lexus were taken. 3 days after the death of John O'Keefe and Karen Reed's SUV being in the Sallyport, those photos that we see of the busted out taillight are from 3 days later. So can they get 3 pieces of taillight over to 34 Fairview, and in the meantime finish damage on the taillight? You get to answer these questions. You get to decide what you believe and what is possible. We are just here giving you timelines and the things that are out there in the rules. But every single one of us out there is a potential jury member of any case. And there could be a case like this anywhere that any of us live. And so these are questions that we need to think about. Because as jurors, the jurors are the finders of fact. And we are just the online internet jurors for this. Then, February 2022 sometime, we don't have an exact date, DGM Petro downloaded videos in 6-hour segments upon Trooper Proctor's first request. This first request contained the front wall camera, which is the blurry camera, maybe the dark video blurry camera, and the front of Canton PD Sallyport, in the Sallyport. Buchanan picked up these and took them to Trooper Proctor. And it said that this stuff was overwritten in 30 days. We find out that they are downloaded before that 30-day time period, and that Buchanan never reviewed the footage before dropping them off to Proctor, according to Buchanan's affidavit. And So anything in February is within 30 days of this incident. But we're going to find out that that doesn't actually matter here, even though that's what we were told, and we're supposed to believe, and everything based on stuff the Commonwealth said. Then, June 2023, Proctor made a second request for exterior Sallyport surveillance camera, a different view. But you're sitting there thinking, well, isn't June 2023 way more than 30 days from January 29th of 2022? Yes, you would be correct. So how is he getting this? So DGM Petro downloaded this entire footage of the time that the Lexus, Karen Reed's at Lexus, was at Canton PD. Buchanan also picked up that CD with a yellow sticky note and took it to Trooper Proctor, saying he did not look at that either. This yellow sticky note had Buchanan's name on it, and then Buchanan wrote the case number on it. So we know this sticky note doesn't seem to be reused, but they like sticky notes or notes up in the MSP in Canton PD. And Trooper Proctor never gave this to the lawyers prosecuting this case for the Commonwealth. The prosecutors didn't know. The law enforcement did, but prosecution didn't. Well, as we just read, it doesn't matter. If the police have it, you have it. Then we move into maybe sometime at the end of 2023, it started, and then it continued into 2024. Not sure. An exact date is unknown, but possibly around February 2024, Trooper Proctor testified at the federal grand jury hearing about reviewing Sallyport videos, and said he hadn't reviewed them in quite a long time. Also stating, we review every video we pull, and we pull a lot of video. Okay. So you've had these for quite a while as of February 2024. And you said you review every video you pulled, and you've made 2 requests before now. And so we're assuming you have reviewed it. You have had it because you reviewed it quite a long time ago, and yet you still didn't hand it over. Then April 4th, 2024, Assistant District Attorney Alley, the ADA Lally, the videos that is missing 42 minutes, and the video of Lexus on the tow truck, which is the videos from Proctor's first request from back in February 2022, because Proctor's had them since then. Lally got a hold of finally over 2 years later in 2024. And then they were handed over to the defense on the eve of trial. Yep. That's how this is going down. We haven't even fully gotten to the good stuff, y'all. Then, on April 10th, 2024, ADA Lally, the Commonwealth, certifies their disclosure of all evidence to the court, saying, you know what, it was all turned over. We've turned over everything that we have. If the Commonwealth has it, the defense has it. And surprise, surprise, it wasn't all turned over. We have been finding out in 2025. And so then the trial won on April 16th, 2024. The jury selection begins in the Karen Read case for second-degree murder, manslaughter while operating under the influence, and leaving the scene knowingly causing personal injury or death. So the second-degree murder and leaving the scene knowingly causing the injury or death, those two are knowingly, that Karen Read absolutely knows she did it. And then manslaughter while operating under the influence is a accident. She didn't intend for this to happen. She may not have even known it happened. So those are her charges that she is going forth on. Then on April 17th, 2024, ADA Lally sends an email to Massachusetts State Police and Canton PD to produce all relevant and material surveillance videos. So when Brennan gets up there and talks about nobody knew they wanted Sally Port surveillance videos, that is a lie. Because Lally knew that they were looking for it at least by April 17th, 2024. Which probably knew before then. And they had it. And they still didn't hand it over immediately. Even though he sent another email shortly after this one saying, hand it over immediately. Props to Lally for trying at this point. Once he just found out about other surveillance video, and the defense is like, I want it all. And everybody wants to say, well, it was overwritten in 30 days. We don't have that anymore. But the police had it, and they knew they had it. Or at least Proctor did. So Hank Brennan is getting up there and misstating the facts about how is the Commonwealth supposed to know what we want if they don't specifically ask for it. Well, they did. And your partner at the Commonwealth, ADA Lally, knew. So miss me with that, I didn't know. How do we know what the defense seems relevant? Well, Lally seemed to know as of April 2024. So go. Chief Rafferty, on April 23rd, 2024, realizing that Attorney Yannetti was not happy with the quality and the intermittent and the not continuous videos that they had received. So now we have the chief of police for Canton now knows herself. Lally knows. Proctor knows. Those are all people that are with the prosecution. That these videos need to be handed over. And that you have them. DGM Petro knows. He's the one downloading this shit. Why Chief Rafferty is watching the trial, if she is watching it and didn't just hear it from somebody, or there was a motion or something that she saw, somehow she found out, which there's a lot of things that you're not supposed to be doing. Like, witnesses aren't supposed to be talking to other witnesses. You're not supposed to be watching trials if you have not been called as a witness, and other things. So could be a huge problem with that. But because Chief Rafferty found out Yannetti was not happy with the quality, she asked DGM Petro to look at other video footage And so the inverted camera, and to download it from the DVR system, and handed it over to the defense. So in April 2024, definitely well after that 30-day overwrite of that DVR system, somehow it's still on the DVR system, and DGM-Petro is able to download this stuff. And as of right now, supposedly, according to everybody, the only people that know about the exterior Sallyport videos is Proctor. So for trial 1, opening statements were on April 29th, 2024, and the trial went on and had its closing statements on June 26, 2024. So it ran between those two dates, those trials. Then we have on June 5th, June 6th, and June 10th of 2024, Buchanan getting on the stand in trial 1. Now, I will say, and do not hate me for saying this, I am going to insert links in the description box that are very well time-stamped by the trial channel of Buchanan and Proctor's testimony, so you can go to the exact topics that you want to go and listen to, or you can just watch it all on your own. But Buchanan does say, Buchanan, whatever you want to say, when Lally asks him about orientation of the video, and he asks this in direct before Alan Jackson gets up there, he asks him about the driveway, and Buchanan says the driveway is on the right of the screen. And so that, I don't remember it watching it the first time. I happened to catch it when I went back and rewatched this. I don't know if that's their way of getting in there that we are trying to give an accurate depiction. Even though it's inverted, we're just going to tell you the driveway is on the right. So it's like, okay, there are bay doors on both sides of the Sallyport, and the car entered from the driveway on the right, but somehow on the video it's entering from the left. So it still is not clear to people, but it is stated, so I wanted to at least put that in there. It's just so quick that you miss it if you're not fully watching and paying attention for extra material. Also, he never denies anyone being at the right rear taillight. He does deny seeing anybody touch it. So Lally asks about certain things, and Lally asks about touching it and destroying it. And Buchanan says, no, I never saw anybody touch it or destroy it. Which in that video, you can't see it. And from what we see in that video, Buchanan isn't there by the taillight. I don't think, at least in the beginning part of it. He may be later, but that is what he says in his testimony. He doesn't say that he doesn't see anybody by that taillight. He says he didn't see anybody touch it or like mess with it. And you can't see if anybody touched it or messed with it in that video because we can't see, because that's on the opposite side. Then, and so that is said. I know there's a lot of statements out there, and so I want to put that in there, and I also want to link that so where you can go to that timestamp and you can listen for yourself. So Don't hate me or get mad at me. I am just reporting what I heard. Now, on June 10th and June 12th of 2024, Proctor takes the stand in Trial 1. Proctor states that Lieutenant Tully is the one who got the videos. He does say that he didn't download them. That's the technicality, which he didn't download them. DGM Petro downloaded them for him. And he had other people download them for him. So he didn't download them. On a technicality, he's correct there. But he's being smart with his words. Because he's not dumb. Even though he acts and looks like a dodo bird. And things between Buchanan and Proctor, you know, they talk about missing times in the video and to it not recording, and, you know, it's motion activated. Although things just are weird. It just starts and stops at weird times, and I don't know. I don't know how sensitive their motion detection is. I know that on most cameras, like if you have a Ring camera or some other cameras, a leaf blows by and it's like, ooh, motion, let's record all this. And you sit there and watch and you're told somebody's at the door. And it's just a leaf that blew by. Just say hello. And you're in there watching a clip, wondering, am I missing something? But none of that did. So is it motion activated? Or is it on a continuous record? It just records continuously. And it's been messed with. You know how we would find that out? Based on the camera and the camera settings. But we'll get to that stuff in a minute and why we can't have that information. Proctor also talks about that's seeing a video. He said the video was not inverted, like Buchanan's part was played in trial. That video was inverted in Buchanan's testimony. And he talks about a yellow timestamp. So somehow he's seen a non-inverted video with yellow timestamps. Now, I don't know if he's talking about he didn't watch the inverted one, whatever, but we know he has reviewed all of it. So he has seen the inverted, he's seen the non-inverted, he's seen the blurry, he's seen all of it. And yeah, it probably did have a yellow timestamp, as we come to find out. Then on July 1st, 2024, right before 4th of July weekend, or when 4th of July happens, the mistrial is declared in trial 1. And then, of course, we find out a little after this, you know, that the jurors are like, well, we did all agree unanimously that she wasn't guilty of murder in the second degree, and we also found her not guilty of leaving the scene knowingly causing injury or death. We were hung on the manslaughter charges. And of course they're dealing with that in the higher courts and stuff like that now. But that is what has happened. But right now we're just going on to trial 2, and who knows if it's going to get stopped or derailed. I mean, something happens every day in this case, and so we don't know. I mean, stuff could happen in the middle of trial. We just have no idea with this. Now, July 2024, Colleen Crawford, who apparently is like the media special or multimedia something, works for Norfolk County office, looked at the DVR and video system in July of 2024 and notices that the video of Karen Read's SUV still exists. it didn't get overwritten in that 30-day time period. That's why back in June of 2023, way after the 30 days, DG and Petro is allowed to download that stuff for Proctor. That's why DG and Petro was also able to download that stuff for Chief Rafferty. Because they had numerous backup hard drives. But no, we don't have it. And she even told, people she doesn't have these videos. And she wrote a report in July of 2024. And this was after the first trial. And it was given to the defense in October of 2024. Why it took that long, I don't know. And the report states that Louis Jutras, which is the IT guy for Canton PD, replaced and disposed of the inverted camera. This is why, at least on the inverted camera, we cannot check the settings of it. We cannot find out if it was a continuous record or if it was motion activated. We cannot know anything about that camera because we just replaced it and disposed of it, which is destroying evidence. You know that camera and the videos that it takes are important. And what's on those hard drives for Karen Read is important evidence in the Commonwealth versus Karen Read. It's insane. Nobody has a brain. I don't know what y'all are doing up there in Norfolk County. I don't know where your education, your common sense, if it's due to drugs, the way you're being raised. I don't know what it is. But something is wrong with many of folks over there. And it seems to be all the folks in power that were working on this case. Now, I do not have anything against people at Canton PD that are working for Canton PD now that were not there when this happened. Canton is usually a low crime rate place. They don't have a lot of crime like this in Canton. And maybe that's why they're complete idiots in Canton. Now, Norfolk and parts of Norfolk, they do, but Canton is not known for crime. It's actually a peaceful little town. It's supposed to be. But ever since this happened, it is not. But moving on from July of 2024, let's move to August 21st, 2024. Chief Rafferty, and this is where I completely lost all respect for Chief Rafferty. She had videos of Brian Higgins at Canton PD on the phone. And those videos came with a note that read, "That's how it records. LOL. No tampering." Are you effing kidding me? The chief of police thinks that this is funny? Somebody's life and liberty is on the line. And a man was murdered or died. A man in blue, one of you, has died. And it's just a big fucking joke. And this is who is leading the troops. Now, I don't know who is worse, Chief Rafferty or Chief Berkowitz. Rest in peace. But these are the people that are the head poobadoos, if you will, of the police department. And this is how they're behaving. And we wonder why the people beneath them are behaving the way that they are, like little children. It's ridiculous. Like, these people do not need to be in charge of anything. But these videos of Brian Higgins at Canton PD on the phone were downloaded during the trial, in the middle of the first trial. Commonwealth, Hank Brennan, gets these videos in late September of 2024 when he comes on the case. And these videos were downloaded to rebut the claims the defense was making about the police department. So, but of course, nobody knew what the defense wanted these. There was never a motion that they wanted these videos. Get out of here with that. But this is how we are getting these clips, these little pieces, these dribs and drabs of clips that the defense has been getting. Instead of all the videos, we're getting these clips from this time period when they are trying to basically put on a rebuttal for the defense. And you want to tell me that you did not know that these videos were important to the case? It does not make sense. It does not make sense. December 12th, 2024, defense expert goes to Canton PD to download the videos from the DVR system. And Colleen Crawford tells him they don't have any of those videos on the DVR system, so you can't download them. And of course he asks, well, where do you have these videos? Are these videos somewhere that I can get them? And Colleen Crawford tells him, they overwrite in 30 days. When we just found out back in July, she knew that that wasn't true because they have numerous backup hard drives. But let's not tell the defense expert that came down. Let's tell him they were gone in 30 days and they don't have them. They don't have them anywhere. Nobody has these things. Ask the defense for them. Well, if the defense had them, they wouldn't be sending somebody down there to get them. She also informed this expert about the clicking and the dragging of copies. From where they are being clicked and dragged from, we have no idea. And clicking and dragging apparently doesn't bring the metadata. That is what I've heard from a technical person expert. That is what has been said. I don't know that myself, if that happens or not, but I'm sure it does alter some of the data. So once again, we don't have the metadata to prove when the video was first recorded, from what camera, how it did, all the settings in it, and then it has dates, and then it has, it'll tell you if it was modified and when it was last modified. We don't have any of that information. And because we don't have any of that information, Brennan's like, you can't prove that anything's been manipulated. You don't have anything to prove it. We might not need the metadata to prove that now. Because Brennan makes a huge mistake. So, January 28th, 2025, Brennan, Commonwealth, turns over the Sallyport videos to the defense. The main driveway side exterior. Brennan said there was never a formal request or motion for Canton PD videos, even though the taillight is the crux of the case. The crux of your case is to prove that Karen Reed's taillight was busted and it looked that way and nobody messed with it, right? Because you need to show that nobody messed with it to refute the defense's claims. And for some reason, nobody thought it was important enough to document her taillight until after 3 days of it being in Canton PD's custody. And so showing that this is how it is, and there's plenty of cases where we have videos, surveillance videos from where evidence is being held or cars are being held, and they get the surveillance video to be like, see, nobody's been in and out of this. The only people that have been in and out are these people. You can see what they're doing. Nothing's been messed with. You know, random people haven't gone in there and everything like that. You see everything that's going on, but not in Canton. We don't know the things that about the car and how the car looked and the murder weapon. The Commonwealth says it's the murder weapon. We didn't know we needed to show that the murder weapon's chain of custody or how it was being stored and who may have messed with it or didn't mess with it. Like, we didn't know. Like, we didn't know that you actually had to keep track of storage and people who have touched things and messed with things. We didn't know you needed to do that. And talks about how this main driveway side exterior video was found in Proctor's file, which we pretty much all knew, at least with guessing, and then when it came out, we were like, oh, surprise, surprise. Now, in November of 2024, the defense requested chain of custody and metadata on the Sallyport videos. There was no metadata provided, and the judge seemed to not think that it needed to be provided or whatever, and she even made the comment about, well, do you want them to create things that don't exist? You can't make them create things that don't exist, right? You're not asking them to produce things that aren't there. But yet, so they're not producing it for the metadata, but magically they prompted reports of past events. So we can apparently get evidence of things that were not there and that they can make up and create. You don't want them to create things that aren't there, right? Well, apparently they did, and they can. So GGM Petro on February 27th, 2025 writes a report about past events instead of them being contemporaneously as required. So when GGM Petro is downloading this stuff, he needs to be saying, you know, I downloaded this video on this date, it was this long, it's on this many discs, and da-da-da-da-da, all the information about it, basically. And then, you know, maybe put it in an envelope or something, I don't know. And then, you know, he signs off on it. And then it can go to, if it goes to Proctor, then Proctor can be like, I viewed these videos in their entirety on this date, and then sign his name, seal it back up, whatever. And then whoever gets them next after that. But it seems like they stop at Proctor. But that needs to be happening when they're actually doing the work, not later, because it's really hard to go back 3 years and remember things fully. So this should have been happening when they are doing things, creating this chain of custody log. And GGM Petro says that Proctor requested the Sallyport videos in February of 2020, 2022 and June of 2023. Then Buchnick also on February 28, 2025, writes a report of the past events instead of when the events happened, saying he picked up the videos from Canton PD at Proctor's request in the spring of 2022 and July of 2023. And then we get to the motion to dismiss hearing in March 5th, 2025. And so that is where we got this timeline of events from, and Hank Brennan's arguments. And it's just, it was like, oh my God, are you kidding me? You've had this entire time. Proctor was in charge of it. Of course he was. But something that Brennan said, he states if the Commonwealth, or the government, was going to hide things, the defense would never have gotten anything. Like, we would have hid them better. Like, they wouldn't have gotten a single thing if we were actually going to hide it. Really? That's how you want to play? That's your flex? And of course, they say Proctor had all the videos, and the prosecution, me and Lally and McLaughlin, we just didn't know until we knew. Well, that doesn't matter, Brennan, because Proctor knew, and he is a part of the prosecution team according to Massachusetts law and the Supreme Court and all that. So stop with that. All right, so that is the timeline. Now let's get into some other interesting stuff that happened that Brennan was not prepared for. And he did not realize some of the stuff that he did. But let's look. So here we have many videos or pictures, sorry. A lot of them are from videos. Actually, 3 of them are for videos. One of them is just a Photoshop, photography. And so my question is do they all look the same? So we have, from about 5 o'clock in the morning, we have this picture down in the bottom right hand corner of Karen Reed's SUV leaving One Meadows Avenue, which is John O'Keefe's home, after she bumped into his Chevy Traverse in the driveway. And we can see how the taillight is lit up. We see red over here in this area, and red here, of course, but none of this part was really messed with. And then there's some white right here, which is interesting. And so Brennan's like, see, it's busted out. Then we go up here to the top left corner where it's got the snow all over it. And you can see that on the driver's side it is red, everything looks intact. And then on the passenger side it's white. We can't really see the side, which is part of an important piece from this view, but this was taken from a dash cam footage, I believe from the wellness check. And the Commonwealth thinks this picture is very good for them, and I would say this is probably a good image for them, because you can say, oh look, the snow was untouched, it doesn't look like nothing's been tampered with, this is just how it looks. My question would be, if I was the defense, is this dash cam recorder on the entire time that this officer is at One Meadows Avenue, John O'Keefe's home. Does it get shut off at any time? Also, because we find out as well in the motion to dismiss hearing that apparently Karen Read says that she had dug some pieces out of where her taillight was cracked, not completely busted, and they were thrown onto John O'Keefe's driveway. Now, if you do not think that maybe there was not enough time to get from the Sallyport to 34 Fairview with the tow truck arrival and then over to 34 Fairview where the CERT team was, could there be pieces of taillight from John O'Keefe's driveway? We only need three taillight pieces for the CERT team to find, to be taken over to 34 Fairview. If this snow driveway picture at John's happened at 8 o'clock in the morning, CERT team stuff didn't happen till 4 something, 5 o'clock, 6 o'clock almost. Could 3 pieces from John O'Keefe's driveway that have been found maybe in John O'Keefe's driveway, or if the dash cam was ever turned off, and then this snow was messed with later, but you don't see it, you just see this. I don't know, I have to go back and look at the dash cam, but let's say the dash cam has that. But there were pieces at John's house that Karen Read picked out of her taillight from when she cracked it hitting John's Chevy Traverse. Could 3 pieces have been taken over to 34 Fairview for the CERT team to find? They only need 3 pieces right now, because it's later that the remainder of these pieces are found. They just kept coming back and finding more, but you only needed 3 in the beginning, very few, and then you can plant the rest later if that is what happened. I don't know if that happens, but that is a question that I have in my mind. Could it have happened from the pieces that they picked up from John's house maybe, and then went and put them over on 34 Fairview, planted the rest later? Don't know. That hasn't been proven either, and it hasn't been disproven. But that is a question I have in my mind. But anyways, we're going from 8 something a.m. now. Then we go to about 4:16 p.m. And this is in Dighton from when Karen Read was at her parents' home and the vehicle was getting on the tow truck. And it is lit up over here, but white over here. Which, weird. Because this is white here, which should be red. And then there is red over here, but in this one there isn't red over here. So where did this red go? The thing is, none of these things look the same. So then we go from the tow truck from 4:16 on January 29th, 2022, over here to the bottom left-hand corner where it eventually is in the Sallyport when they take pictures on February 2nd, 3 days later. And this is what it looks like. And then we've seen the pieces that they recovered and were shown in trial. We covered that in our last Karen Read video, which is called Karen Read the Evidence. And all those pieces apparently amount to this, except for this piece right here. Let's color that in like red. This right here is the parts that never were found and put back together. The yellow piece is still missing once everything is put back together. But they found all the rest of the pieces. Every single little tiny piece. They found every single one. Except for these pieces. It was magically, they didn't miss a piece when they were putting together the rest of this. It's very strange. So do they look the same? What do you think about the theory of them taking a few pieces on John O'Keefe's driveway over to 34 Fairview, buying them time to put the rest of them there to help frame Karen Read, if you believe she was framed? Questions, reasonable doubt. All right, let's move on to the next part. Now we have this inverted Sallyport video that a lot of us, if you've been following this trial, you know about the inverted video. And this is the Sallyport inverted video that was shown in trial, the first trial, and it was shown on June 5th, 2024, when Buchnick was on the stand, day 20 of the trial, if you want to go back and see. Also, Buchnick's testimony, like I said, will be in the description box, and you can click to that time period about the inverted video and where they're talking about it, because the trial channel has done a great job with doing all that for us. But we notice down here that this is a blue timestamp, and the blue timestamp is not inverted like the video. Okay? Very important, all right? This was shown at the trial. Here's supposedly the exact same, from the exact same camera, several days earlier. Nothing's been tampered or messed with, right? Hank Brennan shows this in the motion to dismiss on March 5th, 2025. The timestamp at the bottom is yellow, not blue. So this is the stuff I'm talking about, is the metadata would be great. But do we need, we don't even need metadata. It would be nice to be able to pile on even more. But we can show just by these that something's been messed with. And we need to know how, when, who, why. Just on colors of timestamps. And the thing is, Brennan talks about, I've read the transcripts. You know what the transcripts don't show you? The color of timestamps in trial. Transcripts don't tell you that. A lot of visuals that you don't get to see in the transcripts. That's why watching it is important. Because in reading the transcripts, or if we just had audio of this trial, nobody would know about that. Alan Jackson did pick up on it in the motion to dismiss hearing. But maybe some attorneys wouldn't have picked up on it. And you cannot get that from reading a transcript, Brennan. That's why you should watch the trial. And maybe you wouldn't just be in love with Massachusetts State Police and the Commonwealth and Norfolk and everything, and they're all the best people you've ever met. Is if you watched it, maybe you'd get a better feel instead of just words on a paper. Let's move to the next example, because we had more than one. And Brennan, I don't think, realized he was doing this. He has no clue because he didn't watch the trial. Here we have the dark camera, or the blurry camera. And this was how it looked in the video at trial. Also shown on June 5th, 2024, day 20, Buechnick's testimony. And this is a white text with a thick blue outline timestamp on the bottom. And it's very blurry. You can't really read it, like the clear yellow timestamps that you can read. But nothing was tampered with. You can't prove nothing. You can't prove that anything was altered or tampered with. You are making baseless claims. You have nothing to show that anything has been messed with, Brennan says. Well, explain the timestamps, sir. And you know what I also found very interesting is that they brought up all these videos during Buechnick's testimony. They didn't bring up video with Proctor. When Proctor was on the stand, they didn't bring up the inverted video. They didn't bring up any of that. He talked about some of the stuff, but the videos were not played with Proctor. Proctor did not comment on videos being played in court while he was on the stand. I mean, they had a lot of other stuff to get through, and they got him in through Buechnick, but it was just very interesting when I went back and looked. I'm like, they didn't even play the videos for Proctor to say anything about him. Why? So this is the first trial of this camera. So this is a second camera, completely different camera, not even the same one. Now let's look at what it looked like in the motion to dismiss. White text with thick blue outline timestamp on the bottom. Here's what it looked like when Hank Brennan showed it in the motion to dismiss hearing on March 5th, 2025. Same camera. Just a couple of days before, Karen Reed's SUV was there. It's a yellow timestamp at the top. So not only is it not white with blue outline or looking blue and blurry, it's also not on the bottom. So the placement of the timestamp and the color is different. But no proof that anything has been messed with or altered or changed. It's just how it records. We don't need to show you the metadata. It's just the way it is. You should have watched the trial, Brennan. You should have watched the trial. Because you were outing the misbehavior of MSP and Canton PD while trying to say that they hadn't been misbehaving. And you're showing the world, look at the bullshit that they did. Make it make sense, people. All right, now we are going to get to the juror interference. And so this is a letter that the juror, who was also apparently an attorney, put out after this motion to dismiss hearing, after hearing Brennan's arguments and everything on the case and her. And this juror was excused due to reporting about this juror possibly being on a video that nobody has seen that caused them to be dismissed. So Fanning hears from somebody who maybe heard from somebody, told Judge Cannoni. Judge Cannoni talked to the defense and the Commonwealth, and then court officers were talked to, because people are like, what do you mean, John Fanning? Lieutenant Fanning. And Brennan gets up there and talks about, oh, Lieutenant Fanning is just the best, most decorated officer with the most integrity of all law enforcement that has ever existed in the world, even though he covered up or just chose to ignore blindly, but not blindly, the disgrace of stuff in regards to Matthew Farwell in the Sandra Birchmore case. No, Matthew Farwell did nothing. No. Even though he killed a girl, allegedly. Gotta say that because his trial hasn't happened. Yeah, that Lieutenant Fanning. And we've covered the Sandra Birchmore stuff on this channel. Yeah, he is... Brennan is like fawning all over Lieutenant Fanning. The best police officer Canton has to offer. Well, if that's your best, I don't even want to see your worst. But this is what the juror said. And also, the juror denied the claims that were brought against her by whoever told Lieutenant Fanning that Lieutenant Fanning told the judge. Even though Lieutenant Fanning never saw the jurors, he didn't have anything to do with the jury, apparently. I don't know how he knew what the jury people looked like, or how he verified this before taking it to the judge. The judge didn't verify this. They just took the officer's word for it. And the juror, they said, oh, did you do this? And the juror said no. And they're like, well, goodbye anyways. So, jury interference was talked about, and Alan Jackson talked about how Karen Reed had the right to the jurors that were picked and impaneled, and that without a conference and a hearing on this juror's supposed conduct, she shouldn't have been dismissed. And dismissing her was a judicial error. But here's the statement that she put out. And the juror said, I was a fair-minded juror who left this trial questioning the integrity of the system long before the defense filed a motion to dismiss with allegations of jury tampering. It is the Reed case itself. The fact that it is still being brought that has left many of us in Massachusetts wary, distrustful, and scared of our system. As a lawyer, most lawyers, the reason they do this is because they believe in fair trials. They believe in the justice system. They believe in jurors. And somebody as a lawyer knows how important it is for a juror to go in there and be unbiased and just look at the facts of the case. A lawyer knows it better than anybody. She says, as a lawyer, this reality saddens me even more because I remember how much faith I had in our system as an optimistic law student. She's going back to when she was a law student, and how much excitement and faith she had in the judicial system. And that this is how we can bring the bad guys down and exonerate the good ones, and everybody can get a fair shake. And as a lawyer, I want everybody to have a fair shake. And as a juror, that's what I would have given, is a fair shake. I would have looked at everything fairly. I would have looked at all the evidence before coming to my conclusion. But she continues on. Mr. Brennan made an impassioned argument today regarding his alleged concern that some might be questioning the fabric of our entire judicial system. If he truly would like to address that problem, I have a few suggestions. Perhaps the Norfolk County District Attorney's Office should be more focused on remedying the systemic issues plaguing it and affiliated with police departments rather than continuing to spend millions of taxpayer dollars prosecuting a case with so many evidentiary issues. that it calls into question whether they are even following their ethical obligations as prosecutors. And who better to know those ethical obligations and evidentiary issues than an attorney themselves, right? This is an attorney saying this, who was a juror in the Karen Read case, in the first one. And she was sent home without inquiry, basically, or proof of whatever somebody was saying that she was doing that was bad. She ends with saying, the Commonwealth has a duty to protect the rights of defendants, and I, for one, would love to see them do so. They are not protecting the rights of the defendants. They are not going for truth and justice. They are going for a win and condemning people. Karen Read is guilty to them. There is no innocence until proven guilty. In their eyes, she has been guilty within hours of John being found. Before any evidence had been found, she was guilty in the eyes of the prosecution and Commonwealth. So yes, it would be nice to see the Commonwealth protect defendants' rights. It would be nice if the Norfolk County District Attorney's Office wiped out all these people. It is sad. And I would not want to live in that town. I wouldn't want to even get pulled over for a speeding ticket in that town. Because who knows what stuff is going to happen. And this isn't the only case that's happening, that these issues are happening with. I mean, we just found out today, as I'm having to re-record this, that a Massachusetts State Police person is now fired, leave without pay or whatever it is, because of trying to solicit a prostitute. Like, what the hell is going on up there in Norfolk? And when it's time to vote, people in Norfolk, you need to get these people that are in positions that you can vote out and replace them with somebody better. You need to do that. You need to focus on these little votes that are happening. If you can vote at town council meetings and all of that, you need to have everybody in power stripped down. Get people that are new in there. And your vote can do it. Some of these people can't be just voted out, which sucks. But that's the power that voting has, is that your vote can say, we're not going to deal with this anymore. We don't want you anymore. Make them the outsiders instead of John O'Keefe and Karen Read. Tell them you will not tolerate this. They work for you. All right. So in other videos, I usually leave with a quote of the day. And I decided to do it in this one as well, even though I don't do it in every single video. I do it in some cases more than others. But this says, from Aldo Leopold, ethical behavior is doing the right thing when no one else is watching, even when doing the wrong thing is legal. And it's so true. Just because nobody can see you doing good or see you doing bad, you still need to do the good thing. And just because you can doesn't mean you should. Just because you can do something and you could get away with it, one, doesn't mean it's legal, but two, it also doesn't mean that you should be doing it. Because yeah, some things that are legal aren't ethical. Sometimes they don't equal. Just sometimes doesn't equal fair. And what's morally correct and what's legally correct don't always match either. But the people in Norfolk and Canton, they need to start doing things the right way. And you should have been doing it when no one was watching. But now you are being watched. And whether what you're doing is legal or illegal, you have an ethical duty to your community and the people you serve to do the correct thing. And that town and that county and the community need to hold these people in power to that. It's very, very important for the safety of your town, so that everybody in that town doesn't get railroaded at the end of the day because you're an outsider. You're a community. There shouldn't be outsiders. Welcome people to your community. Even though I live in Texas and California people, y'all need to not move to Texas. We're full. We're full. Go somewhere else, please. We have no more space here in Texas. But we need to do better. You need to do better. And it's just astounding that all this is happening. It truly is. But if you stayed to the end of this, thank you so much. Hit that like button, subscribe, turn the notification bells on so that you are aware of more videos coming out. And I do have a playlist on everything that I've done, Karen Read, so far, and every video going further will be in that playlist as well. Also, I will have the trial channels links and stuff linked below in the description box, as well as the Massachusetts governing laws in there as well. And that is going to be it for me. I will see you later. Bye.